All right, let's pull back the curtain on a pretty intense courtroom drama. This is a story all about legal strategy, expert testimony, and a case worth millions that really all came down to one very critical question.
Right here. This is the whole thing. What happens when an expert witness gets on the stand and says something completely different from what they said before? It's the kind of high-stakes moment that can totally flip a case. So, is it just an honest mistake, or is it part of a bigger, more calculated strategy?
So to get to the bottom of this, we're going to look at the case of Danae Mendonca. She suffered a serious neck injury in a car crash. The defense, well, they hired a very respected radiologist, a Dr. Stephen Rothman, to look at her MRIs and give his expert opinion. And that opinion, it ended up becoming the absolute centerpiece of the entire trial.
And here it is. This is the contradiction the whole case hinged on. Before the trial, in his sworn deposition, Dr. Rothman said it was reasonably likely the crash caused her injury. Simple enough. But then, when he's on the stand, in front of the jury, his story completely changes. He tells them, no, actually, it was an old herniation that had nothing to do with the collision. You can imagine, this was the moment everything changed.
You know, to really understand how serious this injury was, you just have to hear how Dr. Rothman himself described it in that first deposition. He called it a disc extrusion and used this unforgettable phrase, "the jelly is out of the donut." And he made it clear you can't put the jelly back in. It's permanent. That's a pretty serious diagnosis, which makes his change of heart at trial all the more shocking.
So you have to ask yourself, why would a respected expert do a complete 180 like that? Well, it turns out his reversal wasn't just some random event. It actually seems to be part of a very common defense playbook, one that's designed specifically for cases just like this.
It's called the MIST defense, MIST. It stands for minor impact soft tissue. And get this, the term was actually created by Allstate Insurance. Its whole purpose is to give claims adjusters and eventually juries a simple way to label certain crashes so they can justify paying less or nothing at all. The whole MIST strategy is really about one thing: framing a narrative. It's about painting a picture for the jury. You know, that the injured person is a phony, or that there's no way the crash caused the injury. They'll even say the person is just building a claim. And they love to use these analogies, saying the impact was no big deal, like a sneeze or stepping off a curb.
And the main battlefield where this MIST strategy plays out, it's the testimony of the expert witnesses. It really becomes a battle of credentials, a fight to see which version of the science the jury is going to end up believing.
So, a key player in this playbook is the biomechanical expert. These are the folks who come in with all sorts of physics and calculations to argue that the forces in the crash were just too low to have caused the injury. It's basically an attempt to use hard science to say that a real-world medical diagnosis couldn't have happened.
But, and this is a really big but, there's a major counter-argument. The plaintiff side argues that biomechanics is supposed to be used to understand how injuries happen in a lab, not to look at a person who is already clearly injured and then say it was impossible for them to get hurt. It's a subtle point, but it's absolutely crucial.
So if you're the lawyer for the injured person, how do you fight back against this? Well, there's a playbook for that too. First, you lock the expert into their opinion during that pretrial deposition. Step 2, you dig into their finances. How much money are they making from this and who's paying them? Third, you challenge their science. You ask for the specific peer-reviewed studies that prove their claims. And spoiler alert, a lot of times they don't exist. And finally, if they dare change their story at trial, you use their own words against them right there in front of the jury.
Okay, so with that counter playbook in mind, let's jump back into the Mendonca case and see exactly how this went down with Dr. Rothman. It all started by taking a very close look at his career as an expert witness.
First up, follow the money. And wow, was there a lot of it. During his deposition, Dr. Rothman actually confirmed that in just 1 year, his income from testifying as an expert was around $2 million. That's a number that immediately gets your attention.
So $2 million is a lot. But where's it coming from? Well, he testified that a staggering 98% of all his expert work is done for the defense. This establishes a really clear pattern, right? He is almost exclusively hired by one side.
And the connection gets even stronger. For the specific law firm in this case, Dr. Rothman said he reviews more than 100 cases a year. This isn't some one-off thing. We're talking about a long-term, high-volume business relationship.
The plaintiff's attorney took all these numbers and just boiled it down to one simple, powerful point for the jury. He argued that Dr. Rothman has a multi-million-dollar job, and that job is just to say no, to deny the injury, no matter what the evidence might have looked like at first.
So the stage is set. The jury knows about the money, they know about the potential bias, everything. And now it's time for the main event, confronting Dr. Rothman on the stand about his changed story, using his own sworn testimony to do it.
The lawyer doesn't beat around the bush. He gets right to the point, laying the contradiction out there for everyone to see. There's no escaping a question that direct.
And what's the response? Dr. Rothman tries to dodge. He says, "I'm not sure I said that," and then points out he doesn't have a copy of the transcript with him. It's a classic move when you're caught in a tough spot. But the lawyer, he was ready for it.
And boom, this is the checkmate moment. The lawyer pulls out the official transcript and reads the doctor's own words right back to him. Not just reasonably likely, but certainly reasonably likely. The contradiction is now completely undeniable, proven by the court record itself. And just like that, his credibility is toast.
So with the defense's expert witness pretty much dismantled, the plaintiff's attorney moves on to his closing argument, and he frames the final choice for the jury, not as some complex scientific debate, but as a simple question of fairness.
He used this really powerful language. He argued that the defense had spent the whole trial trying to get a discount on justice by downplaying the injury, by attacking his client, and then he told the jury, the time for a discount is over.
This was really the heart of his entire plea. He told them their job wasn't to meet in the middle or find some compromise. Their job was to deliver full justice for the full amount of harm that was caused. Full, not partial.
And finally, he put a number on it. The request was for $1.1 million. So after watching an expert's story get taken apart and a whole defense strategy get exposed, the jury was left with one last massive question. What is the price of full justice?